I'm Roger Citron. I'm a professor at Toro Law Center, and I'm delighted for our guest tonight. He's Barry Friedman. He's a professor at New York University Law School, and we'll be talking about the Supreme Court. And so, Barry, let me first let people know that we're having this conversation in late August 2022, which means we're sort of between Supreme Court terms. And we'll certainly get to the court soon enough. But first, please tell us a little bit about yourself.
Sure, Roger. It's great to be here. I'm a law professor at New York University School of Law. I teach a lot of the public law courses, and over the course of my career, I've taught administrative law and constitutional law and civil procedure, and I've even taught contracts, so that might have been malpractice. The thing I teach the most about now is criminal procedure, and I run an institution at the law school called the Policing Project, which works with communities and policing entities and all stakeholders to make policing democratically accountable and transparent and equitable. But my first monograph was called The Will of the People, and it was about how public opinion influences the Supreme Court. And if you'll forgive a little pitch here, I, along with a number of co-authors, have written a book called Judicial Decision Making that is actually a course book that marries the social science literature about why judges behave and how judges behave with the number of institutional problems at the Supreme Court. In each chapter of the book, we have chapters about ideology and judicial selection and the negotiations among judges on a multi-judge court and separation of powers, things like that. Every chapter begins with some story around a major case, whether it's the Obamacare controversy or whether it's Iowa Supreme Court justices legalizing same-sex marriage and then all getting tossed off the bench. And I have to say, finishing the last term, I felt like we needed to replace all the cases because we got so many blockbusters in one term, and they could easily serve to be the chapter headers of all the chapters. So I know that's where you're going, and I thought I would give you a segue.
Absolutely. And when you referred to your first monograph, the reason why we're talking is because when I taught a course on the Supreme Court, I assigned, I think, the law review article version of your account of FDR and the New Deal and FDR versus the court and how public opinion informed that. But of course, let's talk about the current Supreme Court. And I think, it really isn't in dispute. That is that the public opinion, the approval of the court has declined recently, that is in the last year or so. When we were corresponding, I sent you a link to a CNN poll. I've seen more recent ones that are sort of consistent with that. And so, again, talking about the current court, what are your views on why there's been this drop or decline in public approval for the current court?
So I'll answer that, but before I do, I just want to give you some context, which is, the court's numbers will go up and down. Sometimes they go up and down, which is to say Republicans love it and Democrats hate it. So, after Bush versus Gore, there was a drop, but really it was kind of a drop among Democrats and an increase in Republicans. Here, I think you're seeing, I won't say across the boards, because there are certainly people on the farther right who are applauding what the court's doing, but certainly among Democrats, but also among independents. I mean, I saw a number of 22%, and that's totally impressive. Like, that's really low. And so, why would that be? And I think the word that jumps into my mind, though there's much more I could say, is unseemly. This is an unseemly court that has been put in place through unseemly circumstances. It makes you kind of want to cringe or grimace a little bit, whether it was the ridiculousness around not filling Justice Scalia's seat and holding it, which or whether it was the race to seat Justice Kavanaugh, or certainly the shadow docket, which I suspect we're going to talk about, as Steve Vladeck has refers to it. Actually, I think Will Bogg might have been the first person to call it that. People it's funny, people may not always know about all the issues, but they know it when they see an agenda that feels like it's being pushed a little too hard, when things are a little smarmy. People can get a whiff of that and it affects how they feel. And I really do think we are living in a time when this is just a gallop toward results-oriented answers. And that is definitely driving how people perceive the court.
Although, and sort of in that answer, because you mentioned Bush versus Gore, I hope I'm not re-asking the question, but in other words, it's a results-oriented court, and yet it's not being, in other words, it's not a partisan up and down, if you will, or some approval, some disapproval. And I guess, we'll talk a little bit about, it goes beyond results, or outcomes, it seems. And I guess some of that seems to be the nomination and confirmation process, and that of the last few justices. And of course, you mentioned to the shadow docket as well. And I guess in thinking about that, do you think that that is the public opinion? But are these sophisticated questions, or in fact, is there sort of an intuitive sense of fairness that seems to be reflected in the, like the CNN poll, for example?
Yeah, I mean, it's a great question. The thing I guess I want to make most clear is that a lot of it has to do with process. So the public rarely reads Supreme Court decisions, and frankly, the longer they get, the less I want to read them as well. The Bruin case, the gun case, is just unfathomable how long it is. I hope we get to talk about that a little bit. And the public will cheer some outcomes and will boo other outcomes, and that's going to go up and down. That's just a given. But I think there's something about the way things are happening, the nominations process, the shadow docket, which is deciding cases without briefing, the rush to overturn precedent. And it's not like every member of the public is being polled could tell you which precedents were overruled, or what would the right nomination process be. But there's this storm of controversy around the court that they pick up on, and things don't seem to sit right. And it's notable in part because historically the court's one of the branches of government that gets the most respect from the public. I mean, definitely don't be the House of Representatives. I mean, they're the barrel, the bottom of the barrel in terms of what people think. But the justices, people, there's something fetching about the idea with the public. And at the moment, everybody's holding their noses for the court as well.
And let me
Sorry, Patrick, can I just throw in one other thing? I'm sorry, but it just
no, absolutely.
It doesn't help that there are all these justices running around saying we're impartial and independent. It's like we think they'll protest it too much.
Yes. I think when you play poker, that's called a tell. Let me try, or we certainly will come back to the current court. But it may be helpful, I think, for at least, I know it was for my students, what's different about, if you will, the politicization or the politics of the court today compared to something like the New Deal. And I wonder whether, for example, I mean, one of the things that I still am struck by was, it was, in other words, we simplified the New Deal down to, well, FDR. But of course, it was FDR, as well as, in Congress, there were these really strong elections. And so that's one thing, I think about it. And when you compare these, the past, the 1930s to today, but let me ask you how you see the comparison between the New Deal era and the current era.
There's this wave of decisions. It goes up and down, and times when the public approves of the court, and times when it's mad at the court. Depends a lot on what the court's doing. certainly around when Thomas Jefferson was president, during the time of Dred Scott, Reconstruction, the Lochner era, the New Deal, the Warren Court. Like, you could kind of go on and find your periods in history where there were issues. Though I will point out that the Warren Court was actually wildly popular all the way up until the very end, when crime rates sort of undid it. And so, each story is a little different. The New Deal, Roosevelt is the right figure to focus on. He was definitely a larger than life figure. He had enormous majorities in Congress and in popular elections, and the country was suffering badly. And everybody got the message that there were these, schnooks on the Supreme Court that were standing in the way of living better lives. Now, whether that's true or not, there's a lot of literature about whether, the New Deal would be effective and whatnot, but that was the image that the public had. And there were certain mantras out there, like, one of them was Roosevelt gave this famous speech about a horse and buggy court. And it was all about just getting the idea that, here we are in modern times with a modern economy, and there are these Neanderthals that are kind of holding everything back. But I don't think that's what's going on now at all. I really, and again, I'm my opinion, and the right amount of money will get you a cup of coffee, but I have been watching this for a very, very long time. And I just think that the court has just stepped all over its own institutional credibility. So can we just talk about the Chief Justice for just a minute?
Well, yes, that's exactly when you say institution or institutional credibility, that's the secret word for Chief Justice Roberts. So please.
So, I probably shouldn't say all this publicly, but oh well. When he was chosen, I really thought, in some ways he was just going to be the devil in terms of any progressive agenda. And there were a lot of progressives that I knew who knew him who were like, he's really terrific. And I thought, he's smart and he's charming. And I thought, well, what do you think the devil comes looking like? I mean, the devil's not going to be unattractive and unpleasant. The devil's going to be the most charming person you've ever met. And Dahlia Lithwick and I wrote a piece in Slate that kind of compared him to a magician, manipulating things so that people, didn't see things disappearing or whatnot. And I don't know that he's ever looked at my book, The Will of the People, but I always say that if there's one person who I think has read my book, it was Roberts, because my book is all about how the court maintains mainstream credibility. And he just seems to really get that. And sometimes I think it's a little, deceitful how, and at other times I think it's incredibly admirable. My admiration for the man has gone up enormously over the years. I think he is brilliant and he really gets it. And he undoubtedly would and had and did move the court in a conservative direction, and one not necessarily aligned with my priors, but you could see people admiring him. His new buddies, on the court, I don't think that there's other than in circles that love them, I don't think there's like a big, Sam Alito Admiration Society or Clarence Thomas Admiration Society. I think people think these guys have an agenda and they're going to cram it down our throats whether we like it or not. And this isn't how we understood the rule of law to go. And so we're not very happy.
Let me stay with Roberts. And so, in the term that just ended, that is in the summer of 2022, I think so. Three of the most noted cases were, of course, Dobbs, Bruin, and EPA versus West Virginia, or West Virginia versus EPA. And Roberts, right, didn't join the majority in Dobbs, didn't write in Bruin, but I think voted with the 6. And then, of course, did write, I believe, is the author of the majority opinion in West Virginia versus EPA. And I just, how do you read, his votes or literally, his decisions in those cases? And how do you think that sort of relates to the fact that, your view of him has you hold him in higher regard than you did prior to his appointment.
So, I'm actually just checking to make sure I'm not going to misspeak here. No, I am not going to misspeak. So, this gives me a great entree into talking about Bruin and also about our judicial decision-making course book, because this is the kind of thing we focus on. So, the New York rifle and pistol versus Bruin case was this case about whether people have a right to carry a firearm in public. In Heller, the court had decided that you have a right to have a firearm in your house, and this is about carrying it in public. And the court was 6-3. And by the way, one important factor about how people regard the court is that it's not often been true in history that one block is all one political party and the other block is all one political party, but that's where we are now. And Clarence Thomas wrote for the majority in Bruin, and his opinion is just wild. I mean, we could talk about it at great length, but he just creates this new form of originalism and wipes away how I always thought we did constitutional law, and then goes on endlessly about the history of gun regulations, and it is just so long and so, I don't even know what adjective to put there. And everybody has a lot to say about it. It's not the opinion for the court. If you look closely, the court is 6-3, but 3 of the majority justices were on separate opinions. Alito wrote his own opinion, and Kavanaugh wrote his own opinion that Roberts joined. And to read Thomas's opinion, it's like a free-for-all out there about guns. But if you read Kavanaugh's opinion, and he's what we call in some of our scholarship and in the book, a pivotal concurrence, because they need Kavanaugh's and Roberts' votes to form a majority. That opinion is way narrower. It's classic Roberts. This law in New York that gave so much discretion to officials about whether to grant a gun license or not, too much discretion, it's not okay. But here's a long list of regulations that would be okay. And that's classic Roberts, which he's much more of an incrementalist. He's definitely got an agenda. He's definitely moving in a direction, but he's got greater caution. And so the EPA case, as you point out, he writes for the majority, and we could talk about it. I don't know what to think of the major questions doctrine, or I have a bunch of views. That's the doctrine that they use in that case to strike down the greenhouse gas regulation. But in Dobbs and Bruin both, he would have adopted a narrower position than the court. And the irony is, Roger, like in Dobbs, the narrower opinion would have been to uphold this Mississippi law that criminalized abortions after, I can't remember what week, but pretty early in the term, in a woman's pregnancy, I think 15th week. When the court decides cases like that, the way they spin in the public is, what a good court. It upheld the right, it upheld the right of the woman to choose. And he understands that trick. And so, and by the way, Citizens United, where, he learned his lesson the hard way because he got smacked in Citizens United by public opinion. And he's learned to just take those incremental positions, and the others haven't.
One more, because I truly find him fascinating for the reasons that we're talking about. Do you think with him that, like, the core, if you will, question or core concern is just what we've been talking about in terms of a long game for the institution and a different game in terms of, keeping the court in a conservative or moving it in a conservative direction, albeit in a slower way? And I guess, is that sort of, is that accurate in terms of getting to the core of how he approaches, or how he seems to approach these controversial cases? And, just to make it a compound question, but about the same one, or is there anything more or anything else that we should sort of know or appreciate or think about when we think about, how he decides these types of cases, the controversial cases?
So, I think if I parse that right, you gave me a 2-factor algorithm, and I'm going to turn it into a 3-factor algorithm. So I think the 3 things that he keeps track of are, he's generally conservative, extremely conservative, and he's, got an agenda. Now that distinguishes him from not most justices. They have agendas. The second is he has a great care about the longevity and standing of the institution. And the third is, I don't think he's crazy. Like he's kind of pragmatic and sensible in some ways. And so I may not agree with him about everything. I don't agree with him about everything. But you know, it's one thing to just be Clarence Thomas. And I just want to point out again, Clarence Thomas only had 3 votes for his position in. They joined. This is what the judicial decision-making course is all about. It's fascinating. He's got 6 justices who join his opinion, so it's the law. But 3 of the people who joined wrote opinions or joined opinions that said something different. And that's Tommy Bennett, Susan Smeltzer, and Andrew Martin and I wrote an article about this, about pivotal concurrences, because it's totally a fascinating phenomenon. But, you know, to read Clarence Thomas's opinion, you have a right to carry a gun around. And we're not even going to do means ends analysis like classic, does the state have an important reason to limit this? Because that's out for the Second Amendment. You just have a right to have it. And the only thing that can limit it is if we can historically find somebody way back there regulated guns in just the way you want to now. And oh yeah, by the way, we know guns are different, and it's all going to kind of be a rough analogy, but basically you got a right to just wield a gun. Whereas, you know, Roberts and Kavanaugh and Alito are like, well, whoa. Yes, you have a right to carry a gun, but the state has a lot of authority to regulate who and how and where. And that's just much more pragmatic.
Yeah, and I have to confess that I think even when I asked, if we go back to the question that I asked about the 3 cases, I think I sort of fell through the trap door in the sense of, I don't think I appreciated, in my mind, that is, I thought Bruen in a certain way was almost the lead. In other words, you know, well, it's a straightforward 6-3, and apparently Roberts had nothing to say about it. And while that may have been literally true, of course, as you pointed out, by joining Kavanaugh's concurrence, and I guess we'll see this play out, perhaps again, all the way up to the Supreme Court, in a way that, you know, what does Bruen mean, or how widely does it apply because of this fractured, if you will, decision. Yeah, let me pivot from Roberts to Kavanaugh, because when you made it a 3-factor algorithm, you put the pragmatic was the piece that I think I had left out, and I absolutely agree. And so, you know, one of the things that I think Justice Kavanaugh and Chief Justice Roberts share is this pragmatic sensibility that comes from having been in government, I think in particular in the White House. And I don't know whether that's correct as a sort of relevant biographical factor, or there's something else going on. But I guess, what are your, in other words, how much do you see, if you will, if we have these different blocks on the court, what is it that, do you see Kavanaugh and Roberts together? I think you do, or at least, substantially do, but I'll let you answer for yourself. And if so, why? That is, why are they, why do they tend to be close in a voting sense?
I can't help but observe that we've certainly had crazy people in the White House. So that, it can't be that like being at 1600 Pennsylvania Avenue makes you pragmatic or sane, not to name any examples. They are, I don't remember the chart. There's this Adam Liptak's end of term wrap up does this grid where he shows the voting agreement among the justices. And that actually goes all the way back to Herman Pritchett, who was a scholar after the New Deal. Roosevelt got to appoint a bunch of justices, and the court's doctrine just changed. And Pritchett was trying to understand what was going on, and he, it's just so wonderful. He discovered voting blocks by like listing all of the justices' names on one axis and then the other axis, and then counting up how many times they agreed with each other. And you could see a sharp break, like there were, this many justices that agreed and this many that didn't agree. And we just saw that with this term, and there's like a 6-3 block. Like that's no news to any of us, but it's interesting to see the numbers. And I don't remember exactly, but I am pretty sure that Kavanaugh and Roberts are voting the most frequently together, either on the whole court or on the conservative bloc. And so that's true. Kavanaugh's Kavanaugh's a puzzle. Uh, you know, I feel compelled to say this. He's a liar. And any number of them have been liars because they just sit there and tell the Senate whatever the Senate wants to hear, and then they go and vote differently. Now, maybe that's fine. I mean, I don't, you can have your own view of lying and candor if you want to. And besides, like, I'm not proud of everything I do to place law review articles, but I didn't create the game. So maybe their view is, well, we didn't create this ridiculous confirmation process, and it is indeed ridiculous. And so therefore, we're just going to do whatever we need to do to get confirmed. And that is clearly what they do. Before the confirmation process, Kavanaugh was reasonably well respected, even in more progressive circles. He wasn't thought to be a crazy guy. His performance during the hearings was despicable. I mean, many people, I'm sure, think that what happened to him was despicable, and we could adjudicate that. Don't get me wrong, but I remember watching him just screaming and thinking, boy, there was a day where, if you screamed at any member of the Senate, you could just forget getting confirmed for anything. Like, it didn't matter if they were on your side or not. And so I add him to part of the unseemly, like what's hurt the court. And then I do think the whole thing about him, Susan Collins and reassuring that we weren't going to overrule Roe, and then just flat out overruling Roe, leaves people kind of scratching their heads. But on any number of other issues, he has been more level-headed. And, the court's moved very far to the right over the last few decades. And so to say that he and Roberts are sitting in the middle is, you need to understand that the middle has, I'm not sure how Zoom is adjusting our hands, but I'm moving to the right here. And so is the court at like lightning speed. And so.
Yeah, those are relative terms. I think we're.
What year did you graduate from law school?
So I'm a 92. So there were, well, when I was in college, senior year was the Bork confirmation hearing in the fall. I was in the fall of 87. And then in was the spring of 91? No, it must have been the fall. It was the fall of 91 was Justice Thomas, that confirmation hearing. And I only because I'm going to sort of complete this, because I tell this to students, I talk about it more now in light of Dobbs, which is that when I was in law school, what overhung, are they going to overrule Roe? I started law school right after the summer of Webster in 89. And then, of course, as I was studying for the bar exam, they decided Casey. And so, even one of my classmates from law school, I think, heard me, I don't know if it was like a faculty colloquium or something, and I said, oh, it's an example of Lochner-ing. And the person was like, right, because that's the only thing we learned for 3 years in law school was Lochner. But that's the context in which I sort of, if you will, got my JD, and sort of really, I think, until September 11th was my con law paradigm was sort of formed in that era. So anyway, that answers the question, but go ahead. I should let you keep going.
Well, I mean, it's interesting. So I graduated from law school in 82.
Mm-hmm.
And, the Chief Justice was
Warren Berger, right? Sorry.
No intellectual himself. The Burger Chief, as one of my professors would call him. And
I've never heard that before. Sorry.
Burger Chief. And William Rehnquist was appointed in 1986. And the story, there was a book written about the Burger Court. So just to back up a moment, there's the Warren Court, famously progressive, maybe the only progressive court in history. It ends in 1968 when Richard Nixon is elected president, and then gets any number of openings, I think 4 justices very early on. And Warren Burger is appointed as Chief Justice, and the big conservative revolution is going to happen. And then, a book gets written, and I can't remember who wrote it, and I feel really embarrassed now.
Is it Blazy?
I can't remember, but the counter revolution that wasn't. And that's the era I came out of law school. But frankly, it was also kind of the end of that period. And I have never known anything but a conservative court. And throughout my entire career, and yours as well, the court has been moving to the right. Like, that's a lot of decades of moving to the right. Lee Epstein and Andrew Martin and Kevin Quinn, Kevin and Andrew invented this way of scoring justices, not just relative to each other at this moment, but all the way across time. Martin Quinn scores, they're called. And when you line all that up, the court's just been moving right for a long time. It is so right. And I remember this book I read in high school called Been Down So Long, It Seems Like Up to Me. And they've been right so long that like right looks moderate to us, or even progressive. And that's like, it's unfathomable what a truly progressive court would look like, because we have lived in that era. And even yet, and I will stop here because there are more things to talk about, including, whether this ever changes, but even yet, like the last year was a head spinner. I mean, it was an absolute head spinner. And
yes, and I think that is, in contrast to prior years under, in the Roberts Court, when you would say, well, the supplement would come out in for the case book, and it'd be like, well, there's one or two, or kind of thing. I mean, one of my colleagues was teaching common law over the summer because we have a program where it's a flex program, and the students have to take courses year round to accommodate their schedules. But the common law person really said, I don't know how much of the book I have to throw out, but I'd really like to get this figured out before the final exam. And so I agree with you that it was a really, double asterisk year for the court. You mentioned talking about the confirmation hearings, and I guess let me ask it this way, which is, as we're talking about the court, and there's been this in rightward direction for literally decades. So if you are a Democrat, or if you are someone who thinks about legal issues differently than the current court, than the six, what do you do about it? And I guess there's, once again, I'm great with the two-factor algorithms, right? One question is the status quo and the confirmation hearings. Can anything be done about that, or within the context of a 9-member court? And then the other one, which seems, so unlikely politically, but the idea of, do we somehow change the court? Do we add seats? Do we do something that changes some aspect of the the structure or of the court in some way? So I'll stop there.
Yeah, so I'm going to answer that, but I just want to go back to where we were for a minute, because it's fascinating, and you said something that made me think of something funny historical. So before this last term, Leah Lippman wrote an op-ed in the Washington Post that was terrific, basically reminding us that we didn't have a moderate court. And the fact that she had to write that op-ed at the end of last term tells you how things were creeping along. But she was exactly right. And in fact, a shout out to her and her colleagues, including my own colleague, Melissa Murray, on the Strict Scrutiny podcast, which has done quite well for itself about the court. And it reminded me that I think it was Thomas Reed Powell, but I don't remember. He was a professor at Harvard, I think, who had this line as Franklin Roosevelt's justices were all of a sudden got their engines going and were deciding cases, where he said, I have to look at the clock when I'm teaching con law to figure out what the law is, because every time the Supreme Court sat and handed down decisions, something major happened. And that was kind of like what we all it was head spinning. What do you do about it? Well, I mean, first of all, I always want to be clear, what do I want to do about it? I have friends who are conservatives. What they want to do is stand up and cheer. Um, and so this is really an ideological issue. And I wrote a paper with a colleague of mine, Anna Harvey, years ago for I think it was at Bloomington, Indiana. They had a symposium, asking in the spirit of true intellectual neutrality and intellectualism, scholarly intellectualism, what can progressives do about the Supreme Court? And Anna and I wrote a paper that said win elections. And so there's a long list of things people think should happen to the Supreme Court. We should fix the nomination process. We should impeach some justices. We should strip their jurisdiction. We should pack the court. There have been times in history where their salaries were frozen. Like, you could take away law clerks. You could put them in a less nice building. I mean, Congress could do just like all kinds of nasty stuff to the court, but it's not going to, because, to quote Hamilton, we don't have the votes. And in fact, so I wrote this book saying that the court stays in the mainstream of public opinion. And everybody's like writing me now and calling me and going, well, you were wrong. And I was, but I'm not. So yes, the court is clearly not at the mainstream of public opinion. What I say, by the way, in the book is over time on salient issues, so give me some time. But it's because they're kept in line by these political checks, and the political checks have completely eroded in our system. Maggie Lemus and I just published a piece in a symposium at George Mason, basically explaining that, called Dysfunction and Deterrence, I think, which is about, you can't punish you can't even get the votes to strip the jurisdiction of the court over something. So if you could, I think they'd be behaving differently. They're not stupid. If they knew that Congress could lash out at them, they'd be careful. Maybe not. Maybe they're just sufficiently crazy that it's like, we're just going to do this because we think it's right. And hey, que sera. But I don't believe that. I think that, it's kind of like the zoo. The animals are out of their cages and running around because, like, the locks aren't on. And so there are lots of things one in theory could do about the court, but in reality, there's almost nothing to do about the court. And the only thing that I think right now that has a chance is that there is some agreement among conservatives and progressives about evening out the appointment process for the court, that it shouldn't depend, the makeup of the court shouldn't depend on what justice dies during which presidential term, but that every president should get 2 appointments to the court during one term. So a 2-term president would get 4 appointments, but that we should have this regularized process of justices dropping off the court every couple of years. And I think you could get support for that, perhaps, and I think it would help restore the credibility of the court in important ways, because I don't think that, the shenanigans that went on, for example, around filling Justice Scalia's seat they're very unseemly. But other than that, Roger, I just got to be honest. I mean, you tell me if you think you see it differently, but I don't. You're not getting any fiery speeches out of Joe Biden, and it may be just because of who Joe Biden is, but he's also a pragmatist. Like, he knows he can't do it.
There's 2 things I wanted to pick up from what you just said. And the first one was just for you to elaborate a little bit on the erosion of the political checks. Is that the gerrymandering piece, or is that even more?
All of it. It's all of it. It's the filibuster, it's gerrymandering, it's people, we're self-segregating in this country. People are going to live in red and blue counties. And so it's the Electoral College, which, I think is a shanda. And if you don't know what that Yiddish word means, that's what Wikipedia is for. So it's all of it added up. And that's what Maggie and I talk about. It's the inability of senators to cast kind of votes that are other than party line on so many of these judicial appointments. And all of it adds up to this inability to really have a functioning political system that will keep an eye on the court and keep it in check.
And the second piece was the idea of every president gets 2, that is to nominate. could you do that by law, or would you need a constitutional amendment?
So I believe you can do it by law. And by the way, I just want to make the point before I explain that, you might think, well, why does that fix things? Well, one thing it does is it creates I'm not a game theorist, but if I were, I would understand that there's a repeat game here now. And unless you think you're going to hold the White House forever, your party, we're going to do to your justices what you did to ours. And maybe we ought to just normalize this process and try to do better. Because we're going to have regular ugliness as opposed to irregular ugliness. I think it's totally doable by statute. Now, I don't think that you can take away somebody's federal judgeship, their Article 3 judgeship. But there have been plenty of instances, I talk about them in my book, and I looked into a few more when the Biden Supreme Court Commission was operating, where whole Article 3 courts have been eliminated, like the Commerce Court, and they just got rid of the judges. They just sent them off to be a judge somewhere else. So, and Sandra Day O'Connor leaves the court, or Anthony Kennedy leaves the court, and they sit by designation in the circuit courts. So you can keep being a judge, but I do not think that the Constitution requires that Supreme Court justices be appointed as Supreme Court justices and stay as Supreme Court justices during good behavior. They have to stay as Article 3 judges. And Congress could set up a system then that would respect that while still acting consistently with the Constitution.
Yeah. No, it's an interesting sort of legal question. And then of course there's the game theory piece about, well, you first, or I'm not going to go first. But I guess that all just comes out, in the back and forth, if we try and actually, commit this to some sort of statutory or legal framework. That is, I'm sure there's a ton of questions, but that's the nature of politics.
Yeah, right. And it's also, somebody's going to challenge the constitutionality, and that's going to be decided by the Supreme Court. And so, I can't guess what's going to happen there. But my hope would be, and again, I'm not hopeful about anything in our current political climate, so do not accuse me of optimism at the moment. I'm deeply pessimistic. It's really been an eye-opening few years. But I think that you could find a locus of respectable opinion between conservatives and progressives on this system fix. And I think if this system fix went through Congress, there's a decent chance that the justices would realize that they ought not to upset it, but who knows?
Let me do one or two more, that is about the current court, because even when you were, I recognized it, or I perceived it as a joke when you were sort of saying the phone calls from people saying, well, you got that one wrong. You weren't wrong when you wrote the book. And you still might not be wrong. That is, I think, this is still in its current iteration a very new court. I know this sounds like a crystal ball exercise, and so it has to sort of be for what it's worth. Do you have any sense of what you think the next, say, 1 to 3 years of this court will look like? I don't think, just to put it in context, I don't think anyone's leaving. It's not obvious that anyone plans to retire. It is, if you will, demographically likely to retire, if I can say it that way. But I just wanted to, get your sense of, will the next couple years, more likely than not, do you think look like the last one, or is there a possibility that, depending upon this fall and 2024, there might be ripples back that may actually have some influence on the court?
First of all, just apropos of who's planning to leave and not. Antonin Scalia wasn't planning to leave either. So, and I think that's what you were alluding to. Demographically. I don't. Neither of us has control over who leaves the planet when we leave it, and none of them do either. And so, there will always be surprises. you know, they could come in completely surprising directions and just have no idea. Um, you know, something tragic could happen to any of them. So my book, I wasn't kidding, by the way. People do call me up and write me and say, "Well, you were wrong," and I understand why they say that. But in the book, I periodicize the court. I divide history into three eras: the age of defiance, the age of supremacy, and the age of equilibrium. And what I say about each of them is, you know, in the early days, nobody worried about judicial supremacy because they just ignored the court if they didn't like what the court did. And you know, that's the apocryphal statement by President Jackson that you know, John Marshall's made his decision, let him enforce it. But the fact of the matter is, the Marshall Court decided one case about somebody who was a capital prisoner, and you know, basically said that was illegitimate, and Georgia hung him anyway. I mean, that was the day. So then what happens is eventually defiance fades away around about the time of Dred Scott, and we start to get judicial supremacy. And once we have judicial supremacy, you know, like, holy whatever, Batman, it's like, what are we going to do about the court now? And that's Abraham Lincoln and the aftermath of Dred Scott, but also other things during Reconstruction. And in that period, we learned how to fight supremacy by stripping jurisdiction. That's ex parte McArdle, if you're, you know, Fed courts nerd, or it's changing the size of the court 3 times to make sure that Lincoln had a solid majority during the Civil War. And all that went along, all to the point where you'd have predicted that the court packing plan would have succeeded in 37, in 36 and 37. And then it doesn't. And I argue in the book that we get into this period of equilibrium, that the justices now understand that if they don't mind their P's and Q's, over time on salient issues, Congress, the president's going to take a swipe at them. But in Maggie Limos's and my piece, we basically are hinting at the fact that there's a fourth period, that we entered an era of political dysfunction. And in that era of political dysfunction, there's no control on the court. Now, I say there's no control on the court, and I don't have a crystal ball, and I do think it's going to be, you know, wild times for the right. They're all licking their lips, licking their chops. But I don't know what it is that the court's going to decide that, you know, people decide to get out in the street. Like, I mean, defiance could happen again, and it could happen at a very micro level, and or at a very macro, you know, like public outpouring of anger. I worry about that in this crazy area we live in with everybody running around with guns. And so who knows what the future will hold. But I think we are in that fourth period right now. And I think in that fourth period, like if I, you know, probably not going to, but if I were going to reissue the book and I'd add a chapter, an 11th chapter that dealt with the period from the book ends in 2005 when Sandra Day O'Connor retires and Roberts ascends to the Chief Justiceship. And I now think it's apt for another chapter because we've crossed another line.
This may be my last question, unless you think there's something that we've, you know, missed so far, which I'll, you know, be happy to continue with. But the and this comes back to, actually, because we were talking about when I was in law school in 89 to 92, and of course the question is, because I took a class from Professor Bruce Ackerman, and I wonder, you know, in your first monograph, if you could just say just a little bit about some of, you know, the intellectual influences, you know, or scholarship that sort of, you know, informed or framed the book, because you know, as we were talking just now about the current court, part of me sort of thought that we may be in the middle of, right, one of these political moments. If that's a paraphrase or accurate phrasing of what he says, right, with the court in response to Dobbs. Not a macro New Deal moment, at least not now. But it certainly, you know, that conversation, as well as, you know, from what I have read, you know, in the book, I just wanted to give you a chance to sort of talk about, you know, where the book came from, if you will, intellectually.
Sure. And then I actually do have one last thing that I think would be interesting for us to chat about for just a second. So, um, you know, I went to law school and grew up learning about the counter-majoritarian difficulty, which was this idea that, that was Alex Bickle's phrase. And Bickle's writing and John Hardy-Healy's writing had a lot of influence on me. But Bickle said, the court is counter-majoritarian, by which he meant we're in a majoritarian system politically, majorities rule, and the court flouts the will of majorities, and therefore it's of dubious legitimacy, and he spent his career trying to figure out how to legitimize the court. And what influenced me to get started in this, you mentioned that you'd read one of my law review articles. I'm nothing like a guy with a sexy name for law review articles, so I wrote 5 articles entitled "The History of the Counter-Majoritarian Difficulty." So that was definitely destined to be a bestseller if you were into the Roman numerals 1 through 5. But it was because I looked around me and I didn't see Bickle's counter-majoritarian problem. It didn't look to me like the court was stepping in the way of public opinion at all. It seemed to be traveling in the middle of it. And, you mentioned earlier, like Webster and Casey, which cut back substantially on Roe versus Wade, I actually think overruled it in effect. But, but this 3 justice group, Souter, O'Connor, and Kennedy, kind of made a show of preserving it, though changing it dramatically. That struck me as just traveling right in the current of public opinion. And so did, death penalty cases. I mean, in Furman, the court basically strikes down the death penalty all over the country, and really quickly it reverses itself, basically, because every state brings back the death penalty, or almost all of them. I think all of them. And so I saw time after time that the court was not really bucking public opinion, but seemed to be floating in the current of public opinion. And that's what led me to write the book. And I say in one of the last chapters, there were a lot of years that people said I was crazy. And so it amused me to no end to watch journalists start to say the things that I said in the book as though they were the gospel. Well, of course, the court travels in the current of public opinion. And you'll remember when the ACA case was being decided, like next to all those stories, there'd be poll numbers next to all of them, as though, well, we need to watch the polls so we know what the Supreme Court would do with Obamacare. And so that was my motivation to write the book. It was a wonderful experience. I really enjoyed writing it, and I've been writing books ever since. So there you go.
All right. And then
yeah,
you have a last word, or perhaps one.
I got a puzzler for you. The University of Wisconsin's law school is having a symposium on, I take it, something akin to like, what are we going to do about the Supreme Court? Eric Siegel has had a big hand in organizing it, and there's a lot of great people coming. I'm going virtually, if not in person. And one of the things I'm going to write about is the whole, what I want, there's a lot of law professors now out there saying what we should do about the court. And I just want to make the point that, great, but certainly please don't think that's novel, because it's happened for 100 years now, at least. And you got to figure out what you're going to do about Congress. But the other thing I really want to talk about, and I haven't figured out how to fit it in, but I got to say it's on my mind, is how do we who teach the law and teach constitutional law and who profoundly believe just how political this is, and even worse than political, the Judicial Decision-Making book is about all the different political influences, and you can tell a really interesting societal story about that. But this is just like, this is what Dahlia Lithwick and Steve Loddick and I said in our Washington Post op-ed that led you to reach out, which is, we're like, enough. This isn't law at all. This is just nothing but we changed who's on the Supreme Court just to get a different result. That's vomitous. And the question is, and yet we're lawyers. We litigate cases, we teach students, and it's our job to teach the law. And the question, which actually, Maggie Loomis and Andrew Martin and I, who are 3 of the co-authors on the Judicial Decision-Making book, and we're going to drag in our other co-authors here shortly, have been talking about like doing a symposium to just ask, how do you teach the law in the age of Dobbs? lawyers? Like, how do you, I mean, my students aren't hearing any of it. They're completely unpersuaded that there's anything like the neutral principles or neutrality or the law operating in this area. And that's a real challenge for us, I think, as lawyers.
Yeah, you know, I don't have an answer, but I can say, um, because I teach civil procedure and administrative law, and I have this interest in legal history that is one of the reasons why I wanted to, take the opportunity to talk to you. Um, and the way I kind of see it is, right, there's this, right, here we go again, two factor, right? In other words, civil procedure is the same course, essentially. The Roberts Court is there's some personal jurisdiction cases and probably some other things that you have to sort of migrate in.
Twombly, Iqbal,
Yeah.
yes, yeah.
But this is, and again, it almost sort of picks up. I guess I'm in an Ackermanian mood or Ackermaniacal mood, as people used to say, in law school, in the sense that, right, civil procedure is an ordinary course, contract is an ordinary course, common law is supercharged. And it's, not only is right doctrine in play, but there's kind of like the fundamental question of what are we doing is in play. That is it even law in some sense? And I have a colleague who, when we had a faculty colloquium discussion about, the most recent term and so on, it was his concern. The way he sort of articulates it is what he calls, good faith, right? That's what he feels is missing, and that's what he's wrestling with, which is another way of, getting back to what you're talking about. What do we do in the classroom in a constitutional law classroom? I'll hit it a little bit this semester in administrative law. That is with the EPA case, for example. I was really struck by, just because we're approaching conceptually, look back at the Massachusetts versus EPA case. I think it is from 2007. Oh, they're talking about, I was so struck by, Stevens dismisses an argument made by the EPA in 2007 based upon Brown and Williamson, which is that, Congress hasn't spoken clearly enough. And that's now vaulted to the majority in the EPA case. That is that reading of Brown and Williamson and the application and so on. And lo and behold, it turns out we've actually had, that's kind of, I may be oversimplifying, but Roberts is saying, no, we've done this before. That is, this isn't, we may have a new name for it, but there's this history of doing what we're doing here. And so it's not new. We're not making it up, kind of thing. So, I hope by the time I write the exam, I hope I have a better answer than I do now. But I agree with you. That is, these are core questions about who we are and what we do. And that doesn't happen often in this profession. In fact, I don't know when it's happened before. And I've been doing this since 2004.
We wrote the judicial decision-making course book for a number of reasons. And if I can,
Please.
put in a pitch here, I urge people to look at it, especially now, because I think you just find it fascinating. The students really do find it intriguing, because it was written in part as a response to, there's always that kid in the back of the class who you say, like, well, why did this case come out this way? And they raise their hand and go, well, because Justice, X is a liberal and they had them, and you just think, and I was frustrated because I spent a lot of time with political scientists, and sure, politics, there's a whole course that gets taught judicial politics, but it's more sophisticated than, oh, well, this person's a Republican or that person's a Democrat or this person's a conservative and that person's a liberal. It's about things like how do multi-member courts negotiate, or what is the game that gets played between higher courts and lower courts in terms of, judges don't just follow stare decisis because the word of God came down. I mean, they don't want to get overturned and stuff like that. And we talk about all that in the book. And it's a very sophisticated view of judicial politics. And I'm fascinated by that stuff. And, if you think about it this way, imagine like the Supreme Court is two teams playing tug of war. And, you expect, if you think of like a cartoon of this, it'd go back and it go forward and it go back and it go forward. And all of a sudden it's like, whoosh. And I think that's what just happened. And because that's just happened, it's really hard to look at the nuanced version of the politics and think there's anything going on. And instead, and I guess this is a good place to end because we're right back where we started. You kind of want to hold your nose and go, this is just really unseemly.
Um, well, we began there, we'll end there. Really, thanks again so much for taking the time to talk with us. It's been a certainly engaging and interesting podcast, and thank you.
Thank you, Roger. It was a lot of fun.